Good morning and welcome to the Economic Development and Small Business Subcommittee on Housing. We will come to order, and would the clerk please call the roll?
Chair Grant?
Here.
Representatives Devendorf?
Here.
Scott?
Here.
Andrews?
Here.
Cerniglu?
Here.
Aragona? Zorn? Fink? DeBoyer? Madam Chair, you have 5 members present. You do have a quorum.
All right. Well, thank you. Representative Cerniglu moves to adopt the minutes from the meeting on May 23rd. The meeting minutes from May 23rd are adopted. Today, we will be taking up legislation for a bit of a refresher. We've had testimony previously on these items, but we do have some new members of the committee. And so we will start this morning with House Bill 4878, which would create the Fair Chance Access to Housing Act. Representative Ayash and Lisa Tenser from the Vera Institute will provide short testimony on the legislation. Please join us.
Good afternoon, good morning. Thank you, Madam Chair, members of the committee. So just wanted to give folks a quick update on this legislation that I know we talked about sometime this session. After speaking and engaging with stakeholders, we ultimately decided that we wanted to extend the look-back period. And for reference, as a refresher, this legislation is one that would deny folks from discriminating upon people who may have had a criminal background. And the idea was very simple. If you had served your time, if you have atoned for the mistakes that you've made through our criminal justice system, then you should not be further punished once you are out of your sentence. So this is an opportunity for us to make sure that those who are coming back and are returning citizens are not denied the opportunity for a fair chance access to housing by eliminating this ability to discriminate simply based on the criminal record. So this legislation, again, after having conversations with stakeholders, we ended up changing the look-back period where rather than you can only look back 1 year, we've now tripled that so that landlords can look back 3 years at someone's sentence. And as we've already discussed, there are going to be carve-outs for specific types of crimes, whether they are human trafficking, sexual assault, criminal sexual misconduct, and things of that nature. So with that, I'm going to pass it over to Lisa, and then I think we'll take a couple questions, Madam Chair, if it's okay with you.
Good morning, Chair Grant and subcommittee members. My name is Lisa Tenser. I am a program associate for the Opening Doors Initiative at the Vera Institute of Justice. I previously worked on fair housing investigations at the Louisiana Fair Housing Action Center, and I'm here to testify in support of the Fair Chance Access to Housing Act. In Michigan, more than 2 million people have a conviction or arrest history. At a conservative estimate, that is 1/5 of the state's population. These individuals and their families face tremendous barriers to housing. In fact, a 2021 survey conducted by the Michigan State Housing Development Authority, MSHDA, found that respondents with conviction histories reported the highest levels of housing discrimination of any group. This discrimination not only devastates individuals and families, but also contributes to increased homelessness and increased recidivism rates, which in turn makes our communities less safe. And I want to focus on the question of safety. At the last hearing, there were many hypothetical situations that were raised. And let's just be really clear, all of us here want to live in safe neighborhoods, myself included. While we can understand a housing provider's intent to keep their tenants and neighbors safe, the current policies that are used to exclude people with conviction histories do not keep us safe. The fact is, this policy will reduce crime and make us safer because people with housing are less likely to commit a crime. Research supports this. A 2021 review analyzing 18 studies from around the world found that stable housing was associated with decreased criminal activity in every single study. Furthermore, research finds that the most reliable factor in predicting future behavior is the amount of time passed since a person's last conviction. So, as time passes after a conviction, a person's likelihood of reoffending drastically decreases. And I have a graph here if anyone would like to look at it. This data proves the importance of having a look-back period for tenant screening processes. Lastly, this bill models the U.S. Department of Housing and Urban Development's proposed rule to lower barriers to accessing HUD-subsidized housing for people with conviction histories that was released earlier this year. Provisions in this rule mirror those within the Fair Chance Access to Housing Act, which include the use of individualized assessments and a look-back period. HUD specifically states that a look-back period longer than 3 years following criminal activity is unreasonable. Michigan, right now, has an opportunity to align our tenant screening policies with HUD's regulations to take the lead on this issue and to enact the strongest statewide protections in the country. This legislation addresses the urgent issue of housing discrimination against those with conviction histories and will help increase safety across the state. Thank you for your time.
Thank you. Do we have any questions, the committee? Okay, all right. Thank you very much. We do have some cards to read in. I am going to start. We have one individual who would like to speak, and so we're going to start with that card. We have Erica Farley from the Rental Property Owners Association.
Good morning. I am Erica Farley. I'm the Executive Director for the Rental Property Owners Association, and I want to thank the Chair and committee members for allowing me to testify today, and I especially would like to thank Representative Ayash and the Vera Institute for continuing to work with us on this legislation and appreciate the work groups that we have had and the movement that we have made on some changes on the bill. Unfortunately, we still have several concerns regarding the legislation. As we talk about the legislation, I know that there is a short list of convictions that are listed that are exempt from this, but we still specifically have concerns about any felony that also has a gun charge attached to it and any kind of violent crime, including domestic violence. Also, we as property owners have a responsibility and by law have to make sure that domestic violence survivors are protected in their properties, into their homes. These are their homes. And if they are at risk, that we need to release them from their leases. And we want to make sure that we are staying within the bounds of that. And this without being able to look back at certain criminal convictions and certain length of those convictions going back, that are we potentially putting domestic violence survivors at risk. We want to make sure that we are having that information and it is available. And we also believe that property owners have a right to know the information, the background of those who are living in their properties, within their homes, and wanting to make sure that the community and the other residents in those areas are safe. So we still feel as though there needs to be more movement on the bill, and there needs to be more expansion on still being able to get this information on potential residents. We understand and appreciate having people come back into the community and making sure that they are productive members of the society, which we fully support, but we also want to make sure on the flip side of that, that people are protected, and especially those who are survivors of any violent crimes, that they are also protected on the other side. So that's kind of our broad view. I'm happy to answer any questions if the committee has them.
All right, thank you, Ms. Farley.
Thank you.
And I'm also going to call up, we have two more individuals who would like to speak to the bill, and I'll call you both up at the same time so that you can prepare your comments. We have Daniel Arnold and Diane Shorter. All right, please join us. Is Daniel here? Yeah. All right, wonderful, thank you. All right, Daniel, Diane, are you going to speak first? Yes. Wonderful.
Christians Hope Co-op Corporation.
Is your mic on?
I have Frank's Christians Hope Co-op Corporation. I help provide housing. I have people from jail and prison that I put in housing, help them get a job, get on their feet, and help them get into school, get into the community, and help acclimate them and be supportive. I'm a law person, I'm a legal assistant, and I'm working on a law degree, so I have an atmosphere, Christian atmosphere to help all walks of life.
Thank you, Diane. I'm Daniel Arnold. I'm a big fan of police work in this city, not an officer myself, but I had my stint with the law, breaking the law in the riots in '99, and I really could have gone down a different path, but the system showed me mercy and grace, and God kept me alive, and now I'm just loving life, and I want other people to have a chance to get good housing. I got a housing voucher, and I really benefit from having good, fair chance housing for me, and I just believe that there is grace and forgiveness in this world, and we want that to be extended to people who are coming out of prison. Thank you.
Thank you both. Next, I am going to read in other cards that we have for people who are not wishing to speak. So first, I have Lisa Chapman from Michigan Coalition Against Homelessness, who is in support of the bill. Thomas Viso, I'm sorry if I mispronounced that, from Michigan Community Action, in support of the bill. Jessica Ack-Moody from CEDAM, in support of the bill. Dakota S. from Nation Outside Detroit, in support of the bill. And Jessica Henry, in support of the bill. We also have Sean Cecil from Michigan Realtors opposing the bill. Amanda Fisher from NFIB opposing the bill. Lee Robinson from the Michigan Chamber in opposition. Holly Tateman from Apartment Association of Michigan, and Jim Kirsch from Property Management Association of Michigan in opposition. All right, thank you very much. We are going to next take up another bill that we have previously heard, which is House Bill 4919, that would establish the Homeless Bill of Rights. It is a bill sponsored by Representative Devendorf, and she will join us for testimony.
Thank you, Chair, for the opportunity to speak to this bill again. I will give a brief overview just because we have already addressed this bill and had much conversation around it, and also because every single person in this room has already stated that they value caring for our constituents who are struggling the most and our unhoused community members. I know that we are committed to this. With the Homeless Bill of Rights, we are setting a baseline standard for how our neighbors can be treated, regardless of their housing status. A lot of what this bill covers should be rights that most folks are able to access, but they are rights and and resources that are often denied to our neighbors who are unhoused. Among these rights are the right to move freely in public spaces, equal treatment by state and municipal agencies, right to freedom from employment discrimination, right to emergency medical care, right to vote, right to protection from disclosure of the individual's records, and right to the confidentiality of personal records, the right to privacy, the right to privacy in the individual's personal property, the same as personal property in a permanent residence, and the right for homeless youth to be enrolled in schools. This is an equality bill. It is not an equity bill. This bill states that our unhoused community members have the same access to rights and resources that all of us do, regardless of their housing status. It offers no additional rights and access. It simply protects what we all already have or should have in order to maintain a stable life. This is establishing a baseline for humane treatment while we are in the middle of a housing crisis, while we build more affordable housing, and while we better resource those who are currently living on our streets. This bill does not make it so that our local governments cannot figure out their own ways to address homeless encampments. As much as you all know, I would love for us to better address homeless encampments in humane ways. This is simply setting a standard. Thank you so much to all of our housing advocates that have helped with this along the way, many of whom have experienced homelessness themselves and have been vulnerable enough to tell us their stories. Thank you to Mike Carl from Lansing's Cardboard Profits for bringing this bill forward, and the original bill sponsor, former legislator Bert Johnson, who brought this bill forward in order to address the crisis of homelessness in Detroit. Thank you, Chair. I have no further testimony.
Thank you. We do have one question from Representative Fink.
Thank you, Madam Chair. Rep. Devendorf, thank you for your testimony. Obviously, I think that you and I would agree that we share a passion for making sure more Michigan families, more Michigan residents are housed, although we've had pretty different approaches. It might continue, but I just have a question about some of the practicality of this legislation. So, I'm just envisioning I think I can envision how you would perceive a person to have been discriminated against for being homeless with regard to like not having a permanent address. That's because like an employer's got to collect like a W-9 or a W-4 or something. Like, what are they supposed to do when they have like a federal form that has an address block? Just what does a person actually do to comply with this in a circumstance like that?
Questions about implementation I always welcome and I appreciate. And you're right, we do absolutely share this as a priority. We already have policies on the books that ensure that different forms of address can be used in these circumstances. In particular, voting is an example of this, where an individual can use a shelter address or an intersection as an address where that can be used on forms in order to access resources. I will also acknowledge before, and to preempt any additional questions about implementation, that because of the state of the housing crisis and our under-resourcing of all of those folks who do direct service, our capacity that we have just about reached in legal services, our direct service agencies will be tasked with helping us to get out information about these expanded rights and making sure to help folks get to our legal services resources. I also know that that is something that our housing advocates are absolutely happy to do to meet the need of this moment. But there are alternative ways that we can make sure that folks have an address on file.
So that's actually, that's you gave me more information like about the voting thing than I already knew. But do you know if a employer can comply with federal requirements if a person doesn't have some kind of an address to list? I don't actually know the answer to this, but I'm wondering if you, because my fear would obviously be a person wants to comply with this act if it becomes a law, but obviously still has to comply with any federal requirements they have, which if you work for somebody, the federal government tells us that they have to know about that. So what is a person supposed to do if they're caught between following some kind of a federal regulation and this act? I wouldn't want to create some kind of state liability for a person who's trying to follow federal law. I don't really think we could anyway, but you understand the tension I'm concerned about?
I understand and appreciate the tension that you're referencing. This is a moment where Michigan can set a standard and then accommodate as these situations come up. You are soon to be in a position to help to set some of these standards as well. So as we encounter issues with implementation, should we encounter issues with implementation and also coordination and compliance with the federal government, we can certainly address those at a later time. As of right now, we don't see anything that would get in the way of Michigan being able to implement this law and protect our unhoused community in this way.
We have a question from Representative Aragona.
Thank you, Madam Chair. And thank you, Representative, for bringing this forward. A year ago, I believe it was the last time we heard testimony on this bill, and I was a little confused as to what rights or what is expanded here that's not currently in law. And you just kind of mentioned that we're not expanding anything. So I guess I'm still murky as to what the purpose of the bill is. But then you also just mentioned that it is expanding rights. So I'm trying to figure out which one it is, and if it's expanding, what exactly are we adding?
I'm happy to clarify. Thank you for the question. So what I mean when I say that these are all rights that folks should have. When we say folks should have certain rights, it means in various pieces of legislation and in various laws, we have already stated that Michigan residents should have access to these rights and resources. That is not in conflict with the fact that people are being discriminated against based on their housing status, based on their sheltered status, and are unable to access a lot of these resources because of that, and that they need additional protection because of that. And we see this across the board when it comes to those that are most impacted by discrimination. When a group is marginalized, when there are stereotypes against them, and in this case, veterans are disproportionately impacted and represented in our unhoused populations, and yet are often unable to access some of those resources, and yet experience a lot of these issues in a disproportionate way. We have so many community members that absolutely should be covered, but simply aren't because folks are exercising what they think is their right to deny people access to those resources. So this puts in statute that regardless of housing status, regardless of sheltered status, that you cannot be denied access to rights and resources.
I appreciate that. Again, it's been murky for a year. Where exactly is somebody being discriminated against because of this, that now with this bill it's being protected, that they aren't already protected in other laws?
So I think my frustration at that question, not with you, but at that question is that we did hear so many vulnerable stories that gave very clear examples of how folks have tried to access the resources and programming that is available, how folks have tried to get into government agencies. We had folks turned away at the door to the Hob because they lacked ID, we have also had people denied their right to privacy while they're trying to access resources. I am especially frustrated by this because I've made it a point to have one-on-one direct conversations with our unhoused community members. And it is a regular experience for them to try to just access all of these things that we already listed: right to medical care, right to privacy, right to employment, to be able to move freely in public spaces. And I sadly, I have to acknowledge that this is not guaranteeing a right to sleep or to put up a residence when you don't have another shelter to go to. But we have people discriminating for existing in public spaces. And this is harming folks. It's also perpetuating homelessness. So I do feel like we have had enough examples from personal stories of people being denied access to these basic resources. This is hard to document because we don't give our unhoused neighbors access to being able to document their discrimination. So being able to protect them and saying that they can't be discriminated against will also help to create a record of all of these instances where folks are being denied access. I also would emphasize that I have not encountered yet in one conversation opposition to our unhoused community members accessing these rights and resources. And which means in this case we have to trust their experience, that they are not receiving these rights and resources that we all agree they should have access to.
Okay, thank you. I appreciate that because for a year I haven't figured out where somebody is being denied access to anything. But you gave an example. So, for instance, here in the Hob, the sergeants would then let in people who don't have an ID, whether they're homeless, whether they're coming to committee or not, whether they come to actually do the business, they're going to have to let anyone in.
This makes it so that it is easier for our community members who are without shelter to access the IDs that we require, to access the paperwork that they often are not able to get a hold of because there are obstacles to government, frankly, for our unhoused population. So I am not going to pretend that I don't want this building to be secure as somebody who regularly experiences threats to my own safety. But this would make sure that our unhoused community members have access to all of the documentation that other people much more easily are able to get and update so that they can have access to all of the spaces.
But that seems contrary to what you said before, because my colleague was just asking, well, if you have an address,
Okay,
you can get an
we're-
address and you
we're-
can get an ID.
You've asked multiple questions. I'm not sure that we're getting to a point where she's able to answer.
I agree. I'm trying to get to a
To-
point to get my answer that I've had for over a year.
Well,
So-
I'm more than happy for you guys to talk offline. But I do think we do understand the gist of your question and the gist of what her answer has been.
Okay, I have one other question on a different subject from what exactly the bill does. Do you mind if I ask
All right,
that?
this will be the final question.
Okay. You mentioned that intersections can be used as addresses?
Yes,
Okay.
yes. Under other examples for how to address and resource our unhoused community members.
So when we were talking about this bill before, I actually got a number of people from my district asking, will this allow for tent cities such as in Denver, which is completely ruining the city? You said it's not leading to that. However, if you can use an intersection and we're protecting people's, we're putting in statute that you can protect people's their things, I don't understand how it's not going to lead to that. Or, we make laws. Judges don't make laws. They're not supposed to make laws. They're just simply supposed to interpret them. I don't understand. Isn't there a thought that this could be interpreted to allow for those type of encampments in public areas where we wouldn't want them?
I'm thrilled to answer this question. This bill addresses the reality of our housing crisis. The reality of our housing crisis is that there currently are not enough roofs to offer people who need a place to live. Therefore, the nearest intersection that they regularly pass is one way we have addressed this problem to make sure that we don't deny people their basic rights. We cannot make our neighbors who are unhoused disappear or magically move them into housing, which is not to say there aren't best practices for resourcing encampments so that they aren't permanent and so that we can gradually over time shift folks into permanent housing. This bill does not sanction encampments. That is not to say that it doesn't recognize that homeless people don't become housed by some magical measure. We have to acknowledge that there are people living in the streets, and in numbers we have not seen in quite some time. More children than we have seen, more seniors than we have seen. This is a crisis, and people are outside. Considering that, we have to acknowledge the reality of the situation and get as close to where they are most often in order to make sure that they have a way to receive resources. I have given an example before where I became very close to one of our members of our homeless community who started to come to the bookstore that I had because he needed to connect with DHHS, who kept leaving sticky notes on whatever his prior residence was. He was somebody who used sign language, did not have regular access to a phone, and I would make those calls for him while we wrote notes back and forth to each other. He finally found housing, but was denied that housing because he had lack of a rental payment history. But he also had a very difficult time at being connected with the folks that would be his caseworkers because identifying that address and making clear that he needed a way to be with them in person was not easy and frankly was not respected. This bill is to establish that baseline for we cannot deny anybody these steps, not additional, these steps that would ensure that folks could be connected with and resourced so that they could shift to permanent housing. That is the overall primary goal, is getting people into housing. But in order to do that, we need to be able to resource them and be in contact with them regularly in order to make sure that we get to the root causes of homelessness.
So it doesn't sanction it, it just protects the ability to do it.
It doesn't sanction encampments and permanent residences outside, but it does protect the rights of our unhoused community members to all of our resources that are provided to everybody else.
Thank you, thank you. Thank you, Representative Devendorf, for your testimony. Thank you, representatives, for your questions. I am going to read in some cards. We have Lisa Chapman with the Michigan Coalition Against Homelessness in support. We have William Lawrence with Rent is Too Damn High Coalition in support. We have Jim Shafsma with Michigan Poverty Law Program in support. We have Amanda Fisher from NFIB in opposition, and John Shea from the City of Wyoming in opposition. All right, thank you. We need a motion to refer House Bill 4919 with recommendation to the Economic Development and Small Business Committee. Representative Andrew moves. Madam Clerk, will you please call the roll?
On the motion to refer, Chair Grant,
Yes.
Representatives Devendorf,
Yes.
Scott,
Yes.
Andrews,
Yes.
Cerniglu,
Yes.
Aragona,
No.
Zorn, Fink,
No.
DeBoyer. Madam Chair, you have 5 yeas, 2 nays, 0 pass. The bill is referred.
Thank you. House Bill 4919 is referred to the Committee on Economic Development and Small Business. Representative Scott moves to excuse absent members. There being no objection, the motion prevails, and there being no more business before the committee will stand adjourned.